So we've heard a lot about design patents over the last year. Can you talk a little bit about this?
Sure, I'd be happy to. Starting in September of 2008, the Federal Circuit handed down its landmark decision in the Egyptian Goddess versus Suiza case, which was a case involving the test for design patent infringement. The patent bar had been waiting over a year to get the results of that case. And prior to that case, the test for infringement of a design patent involved a two-step process. The first step was to compare the accused product with the patented device to see if the two had the same overall ornamental appearance. And if they did, then the law at the time was that you would go to a second part of the test, which was, did the accused product misappropriate the novel elements of the design patent? And that's the part of the test that the Federal Circuit actually did away with. The reason why they did that was because the novel elements test really became a moving target. You had the patent holder putting forth novel elements that the accused infringer may have copied, and you had the accused infringer arguing that what was novel about the patent was everything they didn't copy. And so the Federal Circuit took the position that this novel element requirement wasn't even required in order to get a patent from the patent office, and so this additional hurdle during the infringement stage didn't make any sense. And so they did away with that. And so that was a real landmark decision for design patents that really started the ball rolling with a lot more interest in design patents. The sense is that based on this decision, it will be much easier for patent holders to get a decision of infringement from courts. And so this is seen as a real advantage to design patent holders and not a great thing for those who like to copy products.
Okay, great. Looking forward over the next 6 to 12 months, though, do you think we'll be hearing more about design patents?
I absolutely think we will. In addition to what's happening in the courts, which is now the district courts are all interpreting the Egyptian Goddess case, there's also a lot going on Capitol Hill. There's several pieces of legislation that were introduced this year. The first one involves what we call the Fashion Design Bill, and that's an attempt by primarily fashion designers to create a copyright-like protection for apparel and apparel accessories, so things like shoes and handbags. What they're trying to do with that bill is create an amendment to what's known as the Vessel Hull Protection Act, which is another carve-out really for boat designs in the Copyright Act. And so the hope is, for those that are proposing the legislation, is that designers will be able to protect their designs through more of a registration system than a patent system. The advantage of that is that designers often come out with more than one product in a season, and so if they can find they see this as maybe a more affordable way to protect a lot of designs at one time. The other piece of legislation that was reintroduced this year as well is what we call the Crash Parts Bill, and that, as you can imagine, is being promoted by the insurance lobby, who would like to be able to import what they consider to be less expensive copies of car parts. A lot of companies are now patenting their designs for the car parts, not just the car, and the insurance companies don't necessarily want to pay a royalty for importing those parts. And so it's not clear whether either of those pieces of legislation will make it through in this session of Congress, but there's an expectation that if they don't, they'll probably be introduced again next year. And so I do see quite a bit of interest continuing in the next 6 months to a year with design patents, again, both with this legislation and also just seeing how the district courts interpret Egyptian Goddess.